Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday from 5 to 6 p.m. Central Time, Reddy Neumann PC is bringing the news immigration updates from past 3 years. Emily, more than that, of course. Emily, what do we have today to discuss?
Yeah, today we want to talk about the new settlement that came out with USCIS in regards to processing H-4s and H-4 EADs along with the H-1B petition. We've been fighting for that for over 2 years now. And so we want to give you some tips to ensure that all of them are going to be processed together, what you can do if your company doesn't allow you to file the EAD along with the application. We also want to talk about the layoffs that are happening in the tech sector. Definitely is impacting immigrants, those that are on non-immigrant visas. So we're going to talk about whether you can move back to your home country temporarily and still come back maybe a couple months from now, 3 years from now. Can you come back 6 years, 10 years from now? What are the options? And another question we get quite a bit is, can I get a remote job that's in the US, but actually work from India? This is happening quite a bit when people are stuck waiting for their visa stamping. They get a 221G. They want to keep their job, which is in the US. Can they work remotely? And lastly, we'll talk about the retrogression. We're seeing retrogression in EB1. Now we're seeing it in the rest of the world for EB2. There's a note in the February visa bulletin that it's going to be retrogressing in F2A, which a lot of people have been using in the situation where the main applicant got approved and the dependent spouse is still pending, and we were filing an F2A to get that. Now that might retrogress. So what's going on with those visa numbers?
Emily, congrats for all our team, Reddy Neumann PC. We are the instrumental part of getting the H4 plus EAD getting approved together from now onwards. Are there any conditions to it? What about this? What if, is there a time when this lawsuit settlement begins, or is it already effective?
Yeah, so starting January 25th, tomorrow. So cases I-129, I-539, and I-765 that are received by USCIS starting tomorrow, according to the settlement that we fought for and won, USCIS agreed to process them all together like they did in the good old days before COVID and before the biometrics. So with this class action lawsuit, it started actually way before that in 2019 when the biometrics requirement came in for the I-539 application, and USCIS said, oh, sorry, it takes too long to do the biometrics. We're no longer going to process the H-4 and EAD along with a premium processed H-1B, but we're going to prioritize it and get it approved as quickly as we can. Well, that prioritizing never happened and turned into H-1Bs and L-1s getting approved, and then the H-4 and L-2 are taking a year, 18 months to process. And so we had been filing lawsuits about those delays for a number of months, and the issue kept getting worse. It didn't get better. So we decided to turn it into a class action lawsuit so that we can fix the problem once and for all and not have to continue dealing with this process. Well, this class action's been going on for 2 years now. As part of it, we did get an early win when USCIS agreed to drop the biometrics requirement for H-4 and L-2 spouses. So that was helpful to improve processing times, but still not enough. Another win was getting the automatic EAD extension, because prior to this lawsuit, you didn't get that. If your EAD expired while your H-4 and H-4 EAD were pending, you had to stop working, which was a big problem because these processing times are creating that. Of course, it's a limited help because you need to have the extended I-94 to get that auto extension. And so we were having to do these margarita switch, sending people to Mexico to get that. But it was a workaround that would allow people to get that work authorization. Now, finally, they agreed. If you file starting tomorrow, your I-129, your I-539, and I-765 all together, they will adjudicate them together, whether it's premium processing or regular processing. So they're going back to their courtesy of issuing the approvals, even if they're in premium processing, even though you're only paying one premium processing fee.
So Emily, so the applications that are in the pipeline, do you think so they're going to approve it or they're not going to approve it? What is the solution for those people? Let's say, for example, I have filed a premium processing 1 week ago, and you're telling that this new court judgment is only applicable starting from tomorrow. So if they're going
Yeah.
to only approve my H-1B and my spouse's H-4 and EAD is not approved, what's the solution for them?
Yeah, unfortunately, the settlement definitely does not apply to that situation. We have seen over the last few weeks that USCIS has started issuing them altogether without publishing the settlement agreement, but it's not across the board. So there is still a chance that the H-1B might get approved and the H-4 and H-4 EAD process separately. I don't know if there is a solution other than withdrawing everything and refiling. If you haven't had anything expire yet, that may be an option to be able to take advantage of this new January 25th date. Or, if the H-1B gets approved, go back to the margarita switch option to get the extended H-4 I-94 to get the auto extension of the EAD. That's going to continue through October 26th. So as long as your 765 is filed before October 26th, you can get that auto EAD if you have the extended I-94. I'm hopeful that, again, because they're processing them all together, which the officers themselves said, this is much more convenient and efficient. Hopefully the processing times of those that have gotten separated will improve. But worst case scenario, we're ready to file lawsuits for those that get separated and are still taking a long time.
And going forward, what do you think so in the future? They're going to continue? Does this court judgment has any limitation of 1 year, 2 year, 3 years, or
it does
forever?
have a limitation, but I'm not too concerned about that. So the reason it has a limitation is because a current administration can never really bind a future administration. So they don't want to lock in the next presidential administration into this requirement without them doing it. But at the same time, we're going back to how things were. I mean, since I've been practicing 20 years, they've always approved them together. So I think they can go back to that and not have to change their mind with a new administration.
With regards to with regards to people losing the jobs right now, Microsoft is laying off, Amazon is laid off, Twitter has laid off, and now we have Salesforce. A lot of other companies joining and laying off the tech workers. So, and mostly we see the H-1B people getting panicked. Of course, if they do have an I-140 compelling circumstances, they should be able to try that, and maybe wanting to stay here for a period of 1 year. And it takes about 4 to 10 months almost to get the approval, though. And the compelling circumstances, and there are a lot of ifs and buts in getting the compelling circumstances EAD. That means those people who have an I-140 approval, if they get laid off and they don't have any other company to apply for a job opportunity, and if they are not eligible for H-4 EAD, they should consider the compelling circumstances EAD. But if they still, compelling circumstances just to file for the EAD, they don't have an option of immediately starting working, though, because they will have to wait until the compelling circumstances EAD is approved. And now we know that it may take up to 1 year, anywhere from 4 months to 1 year for the compelling circumstances EAD. So what if they want to decide to go back to India, and then they want to see, okay, let's see the economy moves back to up, and then we're going to come back when the opportunities are better. So these H-1Bs especially, though, who are getting laid off, though, I will speak with you a couple of different options where people don't have compelling circumstances or don't want to consider compelling circumstances EAD. Is, let's say, if they have an I-140 approval, Emily, okay, and they are in the 7th year of H-1B or 8th year of H-1B, and let's say if they go back to India and they want to come back, is there a time limit? Can they come back in 1 year?
Yeah, they can. There is no time limit on that. I think a lot of people are mistaken thinking that they have to come back while that petition remains valid before it expires, but that's not true. And there's another myth that you have to come back within 6 years because the H-1B is only given for a 6-year period. That's also not true. It could be 10 years from now. The only limit on that when you're doing it based on an approved I-140 and you've already spent 6 years in the US is your priority date should not be current. Because if your priority date is not current, then a new employer or the same employer can file a new H-1B petition, get 3 years They have to request consular processing because you're outside the country, but it is not subject to the cap. So it can be filed any time of year, does not have to go through the lottery. And then once it's approved, assuming your visa stamp has expired, you apply for the new visa stamp and come back into the US. And now you've got 3 years. So the only time that 3-year ability is cut off is if your I-140 that you're using, that priority date becomes current and you have not filed the 485. Now you're only eligible for a 1-year extension of the H-1B. You can still get it while you're outside the US, but if that priority date has been current for more than a year and you still have not filed the 485, that ability to get the 1-year H-1B is discretionary. There's no guarantee that you're going to get it. You're not mandatorily required to get it. You have to show that there was some kind of circumstance preventing you from being able to file the 485. So that's just one thing to think about is watch the priority date.
As of now, the people whose priority date is current, Emily, when in general, have you seen any H-1B extensions getting denied because they are unable to file the 485 application?
Not in this current administration, no.
So, so they can come back after 3 years, 4 years, 6 years, 8 years at any point of time. At the most, I'm thinking they're risking instead of 3 years, they may get 1 year. That's the most that I would think. That they can. What about the people who don't have I-140 approvals? Let's say, for example, if they have used up 3 years of their H-1B, and then I say, now I want to quit. I want to go to India and I want to come back when the circumstances being better. When they come back, let's say if they want to come back after 5 years after they leave the country, will they have to go through the lottery system again because it's been more than 8 years by the time they're coming back, they got selected in the lottery?
No, they don't have to. Now you can choose to. Once you've spent 1 year outside, you have the choice of either recapturing the remainder of your previous 6-year limit and not going through the lottery, or going through the lottery to get a fresh 6 years. So yeah, I talked about this in a recent article that was in the Times of India, that I think a lot of people think that once you leave the US on H-1B, that the only way to get back is to go through the lottery again and wait that 1 year out. But no, you can come back while that petition is still valid. If you're with that employer, you can come back after that petition has expired. You just need another employer or the same employer to file a petition for consular processing. And even after it's been 6 years from the time you got your first H-1, you can still come back. There's no time limit on recapturing the remainder of the 6-year limit that you have not used.
So people should not fear if they want to go back, they should be able to go back. And then, you know, at the most, they will be able to come back and use only part of the H-1B. And in the interim period, they can try to get the I-140 approval and get on to the, get on to more than 6 years for H-1B. Emily, with regards to people have fear that what if they go to India and they obtain a job and the job is remote? Can they work from India?
They can. I mean, we get that question all the time and people are kind of surprised. But if you are an Indian citizen, of course you're authorized to work in your home country in India, anywhere, as long as you're physically sitting in your home country. Now, when you're in your home country, U.S. immigration laws don't apply to you. You don't need to even have an H-1B.
What do you mean U.S. immigration laws don't apply, Emily? You mean to say that they don't need to have a H-1B, or they need to have an EAD, they don't need to have an L-1? They can still sit down and work?
Absolutely.
In the company in USA?
Yes. Yeah, no immigration laws can prevent that because you're in your home country. Your home country's immigration laws apply, and that's your home country, so you should be authorized to work when you are there. There may be some tax issues that you've got to figure out depending on whether you're going to be on the US company's regular payroll, or they're going to transfer you to the foreign company's payroll, or they're going to pay you on a 1099, whatever those options are. But those are tax issues that can be dealt with. From an immigration standpoint, I don't see any issues with working in your home country.
If anybody has any questions, guys, I'm a licensed lawyer in India. To tell that an Indian citizen can work in India. Come on, everybody knows Indian citizen can work in India. So the only thing is that when you're remotely working, though, we do not recognize cyberspace as a space. Neither India recognizes, nor US recognizes. I don't know of any country in the world that recognizes cyberspace. So I call it where you're sitting at. That's where your work permit need to be there. With regards to the tax issues, you can also consult a lawyer. I'm a licensed lawyer in both the countries, in India and here too. Or you can consult a CPA, how the taxes are going to work out, though. As far as the immigration laws are concerned, you are not subject to US immigration laws if you get a job remotely, though. There are people ask me a question, oh, how can I get paid? Well, you can just send an invoice to your company. The company can get paid. You can find a company here in USA where they will take the money and they can pass the money there to you. But of course, there will be some taxes involved and commissions involved for those things. You can have your own company in India. This company in US can pay the company in India, and then that company can pay you. You can directly invoice a company here. They can send a payment to you, and they will not be subject to any tax. You on the other end, receiving, and when you're in India, because you're sitting down in India, working in India, you need to report that as an income and pay the taxes there. So that's one thing that you need to take care of. But there is no restriction, none whatsoever at all, with regards to you working in your home country, whichever your home country is. While you remotely log into USA and work in USA, you are not under US immigration laws. Well, Emily, you published, you've been interviewed with the Times of India with regards to the EB1 retrogression and all these other F2As and other options, though. Everything seems to retrogress right now, at least is expected to retrogress, though. So especially, I'm more concerned that a lot of these people who have, some of one spouse got the green card, the other spouse did not get the green card, they should consider to file the F2A as soon as possible if they can. But what about this EB1 category, though? It's been retrogressed to February of 2022. What do you expect in the near future? What do you expect in the long term? And what about the rest of the world, though? And what about EB2 category and EB3 category?
Mm-hmm. Yeah, in EB1, historically, EB1 for India has retrogressed from time to time. In 10 years ago, when that was happening, it was usually in the summer months. So those are the last 3 months of the fiscal year. And it's due to the high level of demand, and they were approving too many green cards in the EB1 category, and they were at risk of running out before the fiscal year ends. And so that's when they implement those cutoff dates. But then the dates would become current again in October. So that was not too big of a problem, just 3 months at the most we had to wait for those to process. But then EB1 started getting more and more popular because EB2 is getting backlogged, just like EB2 got more popular when EB3 was getting backlogged. And we started seeing where EB1, I mean, pre-COVID, before we got the family-based spillover, EB1 was quite backlogged for a number of months. And so I think we're going to be back in that same situation, even though for this fiscal year, we do have the extra 57,000 family-based spillover from last year. Even with that, we're still starting to see that retrogression. And because more and more people are trying to get into EB1, we're seeing people leaving the US, working for a company abroad for a year in a manager or executive capacity, and then coming back to jump into the EB1 category, just like we're seeing people that are maybe now eligible for EB1A, going that route. And because of, and USCIS is, I don't want to say lenient, but they are approving EB1As more commonly than they had in the past. They're not seeing quite as many RFEs or as many denials. So we'll keep using more and more EB1s. That date is going to, I think, stay retrogressed for some time. I don't think it's going to become current in October like it used to. And that also means when EB1 green cards are being used up, that's less spillover to EB2. And more people in EB2 from the rest of the world are using green cards than ever before. So that is causing the retrogression in EB2 rest of the world, and also means there's not that spill across from the rest of the world to EB2 India, which we've been getting for the last couple of years. So even though we have this 57,000 extra, everything is getting backlogged. And then now, same, because we've got people who are previously were getting the derivative employment-based green card. Well, now they have to file in the family-based because USCIS split up the applications. Now F2A, in the February visa bulletin at the bottom, there's a notation saying that they might institute a cutoff date for March. So if you are planning that F2A application, you want to get it in by the end of February.
Can you explain what F2A, Emily, is?
Yeah, so the F2A is the family-based category where you are filing as the spouse of a green card holder. So your main applicant maybe got the green card in the employment-based case is a common scenario we've been seeing. And the spouse, for some reason, there was an RFE or the security check wasn't done. They couldn't approve the spouse by September 6th when the visas ran out last year. So the spouse now remains pending because that category retrogressed and they can't approve it until that date becomes current again. It could be years before that date becomes current, whereas if you look at the F2A category, if they file as the spouse of a green card holder, that category is current. So in order to take advantage of that, you now have to file an I-130 petition instead of an I-140 petition. The I-130 is for family-based, I-140 is for employment-based, but same idea. It's the green card holder proving that they qualify and that they are married to a spouse that they're sponsoring. And then depending on the spouse's visa situation, they may be able to file another adjustment of status if they've maintained their own non-immigrant status, or they may have to consular process the F2A, which should be faster than the employment base depending on the priority date. But now F2A may also retrogress next month.
Emily, let's go to the question and answer. I want to debate a little bit of some of the things. Saratu Jatu, thanks for the class action. We are proud and thankful for you guys. And we have to say, between me and Emily, it's actually the person who did is Stephen Brown in our office, guys. That's the reason we tell people that when there is a chance for you guys to sue the USCIS for the rightful things, though, you should go to the court and you should achieve those things, though. This one was definitely a good effort done by Stephen Brown in our office. He's a partner in our office, just like me and Emily. He's a partner in our office. He's the head of the department for the litigation. And if you guys have any things where you want to consider suing the USCIS for the wrong things, though, what they have done to you, it probably is worth for you to go to the courts. And don't be fearful to go to the courts. Going to the courts, it's like, you're going to the church in a Christian world. This is not a Saddam Hussein or some I don't want to name some of the dictators in the world, but let's say Saddam Hussein was dead. We are in a democratic country, guys, whether it's in India, whether it's in USA. Suing the government is nothing wrong. It's going to the temple. It's going to the church. Is it bad? No, it's not bad. It's the holiest place for the democratic people in the democratic countries to go there. Nothing wrong with it. In Indian, people always ask this question also, why should I be scared? No, you should not be scared to go to the courts. So if there is any delays in the adjustment of status applications, though, it probably is worth for you. If you're getting your EAD and advanced parole delayed, particularly a lot of delay in the advanced parole application, so it probably is worth for you to go to the court and get it done. And speak with Stephen. He may come up with some very creative solutions where you can group up together and go to the court. And a lot of creative solutions can come in if you speak with him, though. Emily, people are asking the question, can we sue the USCIS because not to count the family members? You always advocated, or we always advocated that not to count the family members. We are making everybody write letters to not count the family members. Can we push Stephen to take up the case and get that one not counting the family members?
Yeah, that one's tough because courts have already been asked that question and they've been very hesitant to change the USCIS interpretation. They give a lot of leeway to an agency, a government agency, to come up with its own way of doing things as long as it's reasonable. And they're very hesitant to tell the immigration service, no, you have to do it this other way, unless it's a clear violation. So courts have already been asked that. We've already received some negative results, not on any cases that our office has filed, but there is precedent from other courts that say, nope, we're not going to touch this issue. That means our only option is Congress, which we've all been through that time and time again. They can't get anything done. So the Biden administration is our next option. I mean, the Obama administration created the DACA program. Biden is expanding TPS. Now we have this new humanitarian parole with the stroke of a pen. You can do the same thing with not counting the family members, because it's not in conflict with what the statute says. It's just a different interpretation. So although, yes, we'd love to sue the government on that, I think it's going to be more likely successful to contact the Biden administration, write those letters to get them to change that.
Emily, and you said that, can you explain why, we have to, I know that the law is made by the parliament, which we in United States call it as Congress. And they said that only if the priority date is current, we will be able to proceed with the adjustment of status. So, we are requesting them not to count the family members, because in the law, it's not clear whether they should be able to count the family members or not. So Biden administration can interpret their own way by not counting the family members. And that's the reason, since the law is not clear, we can't go to the court and get that thing granted, though. Now, while law doesn't say the things, Obama administration has created 1 million employment authorization documents for the DACA kids, though. When Biden administration came in, it's called temporary protected status. That means that they grant it for some countries for the people who are living in. For example, at the time when there is an earthquake in Nepal, for the people who are living in this country at that point of time, who are Nepalese citizens, we're given employment authorization, even if they are not eligible for H-1B, even if they are not eligible for any of the employment-based applications, they were being given employment authorization. Now, we know that they have expanded the employment authorization from approximately about 500,000 by the time Biden administration came in. And now we are only 2 years and 10 days or 15 days from the time Biden administration came in. That 500,000 went all the way to 1 million. Now he's proposing to issue the parole, where people from some South American countries will be, or Central American countries will be allowed to come into United States, and they will be allowed to work. And he's not going to the Congress, the parliament. So why can we sue the administration? Hey, you're giving the unlawful people the EADs. You are allowing the Central Americans who are not eligible to come into the United States to come into United States, even though they may have some limitations, immigrant intent, they don't have any H-1B, they are able to come in and work without going to the Congress. Why can't you give it to the employment people who are living in the United States? Can we sue the administration? Or what is the other option?
Yeah, I don't think the courts really can do that. The courts are there to make sure that the administration is following the law, and they're not there to make sure the administration creates new law due to unfairness between different immigrant groups. The main thing here is our only way to get this done is to continue to advocate for not counting the family members, to continue to reach out to the Biden administration on that and send those letters to the USCIS ombudsman so that we can gain more momentum on that, because that's going to be really our only option. I don't see courts being successful for this type of situation, and Congress is also not an option.
We'll go to some questions, guys, as we're going through. Question that comes in is Rajesh. My spouse is on H-4 plus EAD. Can she start her own LLC? Absolutely, she can. No problem with it. She can start her own LLC, do any legal business she wants to. Any legal business she wants to.
And Dheeraj, Oh, sorry,
Sure,
go ahead.
sorry. You good.
Yeah, Dheeraj says, for the settlement agreement, does this apply to petitions that were filed before January 25th? And unfortunately, it does not. It's very clear that USCIS is only going to do this, has to do it by law, according to the court settlement, starting tomorrow for petitions received tomorrow and later. There is a chance that they may still process them together for petitions that are already pending. They have done that in the past. They've been doing that more and more consistently, but there's nothing requiring them to do that, unfortunately.
Questions that come from Ra Gu. Maybe, Emily, I need your assistance in this one, though. He says, can I start my own company using GCAD? Can I contract using my own company? And in other words, he's the primary applicant. Can he start his own company and employ himself? Because in the 485, in the memo of the USCIS, Emily, it's very clear that says that self-employment on the 48, when you are in the 485, you cross 180 days, and after the I-140 is approved and you cross the 180 days, self-employment 485J is allowed.
Mm-hmm.
What do you, did you have any experience when either the main applicant or the dependent might have filed the 485J supplement?
Yeah, we do that from time to time in situations where, you know, the main applicant maybe is facing a job loss situation and an interview is scheduled and coming, and the new job couldn't be found in time for the interview. The person had long been thinking about starting a business, and so this was the perfect opportunity. Started the business, got the website up and running, got the bank account, deposited money into it, and started working on those client contracts to be able to provide this service. So the company that the applicant owned filled out the supplement J form. We clearly specified that it was self-employment. We provided some of these documents. We sent it in before the interview. It didn't make it to the officer in time, but when we came to the interview, no questions were asked about it, no issues at all. So it's very clear that that is allowed, as long as the work that you're doing for the company that you're starting is similar to what you were sponsored for. So you can't be an IT worker on your 485 and then decide to start a McDonald's franchise or a Chick-fil-A franchise. That's not going to work. But you could start a company that specializes in software development, and you're doing that software development work. You have the EAD, so you're allowed to work for that company. You would no longer be in H-1B status at that point, but it is absolutely allowed.
Question from Ju2 is asking question. My spouse is an H-4 EAD. The spouse is intended to file a H-1B. Once the H-1B is approved, can they switch back to H-4? And what is the easiest process for switching back to H-4 so that they can preserve the H-1B 6 years? I would strongly recommend to wait until at least 1 or 2 pay stubs on the H-1B. That's better. It's not required, but it's always better to have the caution. So you can run into, by let's say November of 2023, H-1B is approved, November of 2023. Now you decide, I want to go back to H-4 plus EAD. What to do? There are 2 things that you can do. You can pay a good amount of money to me and the filing fees to USCIS and file the H-4 plus EAD, and it will take anywhere between 4 months to all the way to 1 year to get the H-4 EAD. That's one way. The second way is called Margarita Switch. You go to Mexico, to go to Cancun, have a margarita, you come back into United States, show the H-4 and say that I'm happily married with my spouse, which you are, I'm assuming you're good. Then you're allowed in automatically, and your H-4 and EAD becomes automatic. Pick your poison. Pay us $1,000 plus the filing fees. We'll take 1 year up to, okay, 4 months to 1 year, or you go to Mexico, have a margarita, you come back. Now, I'm assuming that H-4 validity period is still there, okay? In that case, this margarita switch is much better rather than going through the immigration process. Just go to Mexico and come back, no problem. And people ask this question, Emily. I don't have the passport visa stamped in my thing. How can I come back on H-4 when my H-4 stamping expired, but my H-4 797 is still valid?
Right. Automatic visa revalidation is the provision that allows that. So it basically says that if you are in a non-immigrant status in the US and your visa stamp has expired, but you have a valid I-797 approval, you can travel to either Canada or Mexico as long as the trip is for less than 30 days and you do not apply for a new visa stamp while you're there. You can use your expired visa and your valid I-94 to come back in. They automatically treat the expired visa as if it's been extended to the day you're entering so that you can enter on a valid visa. So that's called automatic revalidation and is very useful even for people who have an expired visa, even if the visa that you entered on is in a different status. Maybe you entered on F1 and you've changed status to H1 and now your F1 has expired, you can still use automatic revalidation to travel to Canada or Mexico. Sai says, hi, how will this, the settlement agreement benefit if the company is filing the H1 online and asking us to file the H4 and H4 EAD? I don't see many companies filing the I-129 online, but we do see a lot of times where the company will only file the H1 plus the H4 and the person is on their own for the EAD. You still have options in that particular situation because the H1 and H4 should be approved together. So as long as you file them early enough, once you get the H4 approved, because they'll happen together, if your EAD has not expired yet, you file the EAD extension, and now you have the automatic 40-day automatic extension. So because you've got the extended I-94 with the H-1B. If the situation is you have the I-129 only being filed and then only once that's approved can you file the H-4 and the H-4 EAD, you could potentially use the Margarita switch after the H-1B is approved before the current H-4 has expired. Go out, and when you're coming back in, you show the spouse's new H-1B approval notice, and CBP has been giving the I-94 valid for the extended period that the H-1 got, giving that to the H-4. Now you have an extended H-4 I-94. Now you can file the EAD renewal and get the automatic 540-day extension. That auto extension does expire October 26th of this year. So your 765 needs to be filed before that date. But even if it's filed after that date, as long as you have a valid I-94, the auto extension is still there. It's just shortened to 180 days instead of the 540 days.
This question is for Sandeep Nadella. Got two jobs, got two GC, Can I work on two jobs on GCEAD? Sandeep Nadella. The answer is yes, you can. You can absolutely have two jobs on GCEAD. That's not a problem. Question that came from Manasa. Due to spouse job change, I have two H-4 EADs. One is expiring in 2/23, one is expiring in 2/24. My husband is actually working for the company that is expiring in February of 2023. Can I work until February of 2024? As long as your husband has filed an extension for his H-1B application, and his H-1B application is still pending though, you are entitled to work until February of 2024, even though your husband is not working for the same H-4 EAD company that filed for it. The H-4 EAD is given to you as long as your husband is maintaining the H-1B. You are in good shape. You do not have to stop working after February of 2023.
Mita says, will premium processing be applied to the new H-4 EADs as well? So if the I-129 for the H-1B is filed in premium processing, and at the same time you've included the H-4 and the EAD application, all three will be adjudicated in premium processing. You don't have to file a separate premium processing for the I-539, which that's going to be coming online, but not for H-4s anytime in the near future. And so it only works if it's filed with the I-129. If it's filed separately, it's going to be subject to the regular I-539 processing time, which will hopefully improve, but is still not great.
A question from Khalib. Suppose is rest of the world, and his His priority date is 2019. So his question is, can we file based on supposed rest of the world? He's causing us X chargeability. That is, we call it as cross chargeability. That you can file the rest of the world, absolutely not a problem. If the here is the thing, since the rest of the world is backlogged only until 2020, November of 2022, it's current because yours is current in 2019. So you can use your spouse's country of birth. So let's say, for example, you're born in India, which you're saying you're born in India, and your wife is born, let's say, in China. No, sorry, not China. Let's say your wife is born in Japan. I take back on China. Then since your wife is from Japan, though, you fall into the rest of the world. It's called cross-country chargeability. To file for the 485 application here, though, you cannot file alone your application. You have to file along with your wife. You can file along with your wife, absolutely not a problem, and you can get the green card, and you will be considered to be on the rest of the world category, even though you're born in India. Now, there are some people who are born in Middle East, for example, in UAE or Saudi Arabia. They are born in that country, but they're never given citizenship in that country. Even they will be considered. Let's say, for example, you're from India, your wife has an Indian passport, but she's born in United Arab Emirates, though. For the purpose of the green card, though, you both will be considered on the rest of the world, even though your wife doesn't have a passport of UAE. And of course, you have a passport of India and born in India, but your wife is born in UAE, you come out of the rest of the world.
All right, Vibob says, my perm and I-140 were approved for role A. Now I'm looking at taking on role B, which is changing from an individual contributor to a manager position, and wants to know if my date becomes current while the new perm in process, what happens to the H-1B and green card processing? I would first challenge whether you actually need a new perm in this situation. This happens time and time again, particularly from those from India. I mean, surely the people who had priority dates in 2010, 2011, 2012, by the time they got to file the 485 in 2020, they surely were not in the same job. We've never seen USCIS come back and say that the job has to be exactly the same. No one can say their job is the same over a 10-year period. So even if it is a promotion, we've filed many 485s in this exact same situation, never had a problem. So that would be my first challenge is, do you really need a new perm? There are attorneys that say you do. So you might be working for one of those companies, but check into that. But once the date becomes current, you have that old priority date, you can continue to extend the H1, but it's only going to be in 1-year increments, and you get that first one filed. Hopefully by the time that first extension is over, your perm has been approved, you've ported the priority date to your I-140, and now you can file the 485. Once the 485 is filed, now you can keep extending the H-1B in 1-year increments, or you can rely on the GC EAD. So it only becomes a problem at the time you're trying to extend the H-1 if that priority date became current and you don't have the new perm and I-140 in place, and that date has been current for at least 1 year, then your ability to get that 1-year extension of H-1B is discretionary. We haven't seen problems getting it, but there's a chance USCIS could deny the extension.
Question from Logsami. His cousin came to US on J1, stayed for 2 years, and his H-1B lottery got picked up in the second year, went to India for stamping while waiver decision is pending, though. And his case is still in the stamping, it's still pending. Can we sue? We recommend people who have been pending for the visa stamping for more than 1 month to sue the State Department. It's worth, but in your case, I see a problem there, because what you're telling is that your cousin came on J1 visa. This J1 visa you're telling requires a waiver. I want to explain to people what a J1 visa is. This is for the foreign exchange students or scholars where people come and work. Some of these J1s have a restriction that if they want to change the status to another status, they have to go outside the country and stay. They have to stay not outside the country. They have to go to their home country and stay there for 2 years before they come back into United States. Now, if they want to change the status without going outside to the home country and stay there for 2 years, they have to apply for the waiver, and waiver has to be granted. In your cousin's case, you are telling me that the waiver is not granted yet, and he applied for the H-1B stamping. There seems to be a problem, though, because the waiver has to be granted for him to get the H-1B visa. You said he only stayed there for 1 year. It's been pending for 1 year. No, that's not enough. He should have been waiting for 2 years. Not only that, he must have applied the visa stamping only after he meets the 2 years of the home residency requirement, though. He cannot apply for the visa before unless the waiver is granted. Since the waiver is not granted, he's not stayed for 2 years. That doesn't look to be a nice idea to sue, and that doesn't look like a nice idea for even to apply for a H-1B visa, though.
Arinash says, I'm on H-1B valid till 2024, and the EB-1C was filed because I previously had 1 year of offshore experience in the same company. What are the chances of RFE or denial due to the H-1B, and should I upgrade the I-140 to premium? Do the chances of an RFE increase? So chances of an RFE caused by you being on H-1B is 0. That's not an issue at all. There's no question about what your status is in the EB-1C I-140 petition. They're only looking at, did you work in a managerial or executive capacity for 1 year in the prior 3 years? Are the companies affiliated? Is your current job that you're being sponsored for manager or executive capacity? And has the US company been doing business for 1 year? Your status is completely irrelevant. Now, of course, if you're on an L1A, that gives you some assurance that you probably meet the requirements of EB-1C. But just because you're on H-1B, that has no impact on your ability to qualify for an EB-1C, assuming your H-1B is filed for that managerial or executive position. Or if you're not in that position yet, then that's fine as well. The job offer has to be managerial or executive, doesn't necessarily have to be the position you're in right now. You mentioned that your date is current due to porting. So in that situation, yeah, we generally do recommend premium upgrade. We have seen cases where we're upgrading and they basically send a boilerplate RFE. But even with the RFE, because once you reply back, you get that faster result, I still think it's worth it, even if you get an RFE.
Question. My brother is a UK citizen, born in India. Can he apply for the regular H-1B? Does he have any other options? Please suggest. Well, for the green card purposes, though, he will be considered to be an Indian person, though. But when it comes to the non-immigrant visas, though, he will be considered to be a UK citizen. What does that mean? Of course, there is no special category for UK citizens for the H-1B, though. However, he may want to consider called E2 visa, which Indians are not eligible for. So these are E2 visas are when they want to do business. Let's say, for example, they want to open a UPS store or some small store. They can come a restaurant. They can come and do business on e-visa, though. So he may be eligible for that. People need to consider. He may want to consider E2 if he thinks so that he doesn't get in the H-1B lottery. That definitely is one thing that you need to look into. Venkat has this question. Is there a plan for litigation for AOS EAD approval delays and split processing? Yeah, our office, Stephen Brown, is doing litigation on the delays of the EADs and advance parole for the adjustment of status pending. You may wish to contact him at Stephen, S-T-E-V-E-N, Stephen at rmlawgroup.com. He will be able to respond to that thing. If you are interested in delays for the EADs or advance parole or split processing, you can contact Stephen Brown in our office.
Kemlesh says he filed the H1, H4, and H4 EAD extensions all together in December, upgraded to premium in January, but only the H1 got approved. what can you do for to get the H-4 and the H-4 EAD approved soon? Unfortunately, there's not any action that you can take to cause USCIS to approve them quickly because they were just filed in December. They're still within normal processing time. Because the settlement hadn't happened yet, there's no requirement for them to process them all together. But because you have your H-1B approved, assuming your spouse's H-4 I-94 has not yet expired, you could travel to Mexico, show your H-1B extended approval and the H-4 visa that has not expired and come back in, and very likely get the I-94 extended for the H-4. Then she's automatically eligible for the EAD auto extension for the 540 days, so that even if her H-4 processing time takes a while, as they will continue to process that application, she can still work because she's got the extended I-94 and you're just now waiting for the EAD card to come in the mail.
Question, very interesting question that came from Prashant. My wife is planning to move from H-1B to H-4. At the same time, he is intending to change the employer. His question is, does he come under this litigation? Can he take advantage of the settlement that we have? When he is moving from one company to another company, his wife will file change of status from H-1B to H-4 plus EAD. Absolutely, you can. You should. If you file together, I'm absolutely sure they will approve the H-4 plus EAD as long as you file it starting from tomorrow. I don't see any problem in it.
Ramesh says, I have an L1A with an approved EAD and pending 485, but I was laid off. Can I work for another company and still get the green card? I have my I-140 approved and I have the EAD. Will it impact my GC approval? Will it get denied? So you have the I-140 approved. I'm assuming at this point your 485 has been pending for 180 days and you have the EAD. So as long as the new job is similar to the job that you were sponsored for, yes, you can move to any other company. You're not stuck with only this L1A company because you were on L1A or because they sponsored you for EB1C. AC21 does apply to EB1C. So once you have that EAD and your 485 has been pending for 180 days, you can move to any other company as long as the job offer is similar to the one that you were sponsored for.
I'm getting a question in the same lines. I got the EAD and AP in September of 2022. Can I work a part-time with a 1099 along with the current W-2 form, or do the two jobs have to be W-2? Legally speaking about, the second job can be 1099. We don't see that as a problem. It can be 1099. You absolutely have no problem for it. Yeah, if the primary job is on 1099, only one job though, I definitely recommend that you consult a lawyer. It's not that you cannot do it. We recommend that you consult a lawyer before you do that.
Free Karar says, can we apply for the H-4 online and then the H-4 EAD through the mail? Technically, yes. I don't think I would recommend it. We don't get a lot of interaction with the online system because it doesn't allow you to have an attorney when you're filing online. But it's going to create some problems because you file the H-4 online, you get that receipt notice. Now you file the H-4 EAD by mail. You're not going to get the H-4 EAD approved until the H-4 gets approved. They're not going to process them together because they were filed separately. So you're not gaining anything by doing that unless, of course, the H-4 happens to get approved quickly because it's online. But then how do you notify the office where your H-4 EAD is pending that your H-4 has already been approved? There's not a way to contact them. You can try to interfile it. I tried that multiple times. It doesn't work. So yes, technically you can do that, but I don't see any benefit to it.
Emily, I want to speak about people who are getting the H-1B approval. Either they are on other visa status and they don't have a social security number. Let's say I just came from India, I'm an H-4 and I got the H-1B filed. I don't have the social security number. And it's taking nowadays almost 5-6 months to get the social security number though. What's the solution? Can I be employed by the company when I apply, get the H-1B, apply for the social security number?
Yes, absolutely. And that's really important to know because I think a lot of employers don't know that and tell you you can't work until you get your social security number. Completely false. So the company just needs to fill out your I-9 and they'll leave a space saying social security number has been applied for. And if they're an E-Verify company, they have to hold off doing your E-Verify because they can't do it without a social security number. But yes, you can be employed. You can even be paid. There is a link on the Social Security Administration's website that very clearly says you can work while your social security number is pending if you're in a work authorized visa. So definitely you can do that. Make sure that you are getting paid because an employer cannot say that I can't pay you because you don't have your social security number.
Guys, we're also getting a lot of reports from the companies who have filed multiple H-1B applications. They are getting revoked when companies like, let's say, for example, one company having 5 different brother sister companies filing for the lottery system. Those things that were filed 2-3 years ago, they're getting revoked. So if you are one of them, you may want to contact the lawyer, though. That's very important for you to contact the lawyer because there may be some solutions. At least you can get some financial gain before somebody takes all the money from the company. You may want any money that you have paid, any expenditure that has been incurred. You may want to get that expenditure back from the companies. You can always resolve the other issues later on, but at least get the money that the company owes you, though. That's very important. Most of these companies are getting hit very, very bad right now.
Yeah, and they're even getting a lot faster. I mean, I had a consultation yesterday for one that was filed in May 2022, but already issued the notice of intent to revoke for that. But before they were doing it 3 years later, but now it's in the same year.
Yeah.
Santhi says, why are the prevailing wage determinations taking forever these days? Is there anything the employer can do to make it faster? Yeah, they're definitely taking forever. There's a number of factors that went into that, COVID being one of them, but the main one really is the Trump administration's attempt to change the way prevailing wages were calculated. If you remember back in 2020, the new wage actually went into effect until a lawsuit blocked it. So everybody was trying to get their prevailing wages in early so that they could get under the old wage system. And then the new wage came into effect, and then they had to reverse that. So all those wages that they issued under the new wages, DOL had to go back and reissue them under the old wages after the lawsuit. So there was a high amount of filing trying to hit that deadline in order to not be subject to those new wage calculations. And then there was a bunch of repeat work that had to be done because of the lawsuit blocking it. So that was part of it. And then on top of it, you have everyone taken by surprise by the October 2020 visa bulletin. All these people who had just changed jobs, now they're telling their employer, hey, hurry up and file my perm. So everybody's filing prevailing wages in October 2020 so that they can hopefully get the labor and I-140 approved with the new employer, file the 485 before the dates retrogress. On top of that, they've got H-2Bs and H-2As that they have to prioritize because they have a very limited filing window and they are also subject to a lottery. That's a very difficult process to get through. All of that's happening right now. So they've got to drop what they're doing on one side to hurry up and do work on the other side and then do repeat work. And then also there was a change in the SOC codes that happened. Some of the codes don't have all of the data available yet. So as DOL is issuing those particular prevailing wages under those codes, they're having to go back and enter that missing data. So all of these things are combining. We've been looking into the possibility of litigation for that. I do think that it's a viable option because they're definitely unreasonable. I think one of the difficulties is with this type of litigation, got to be the employer that's the one that files it. It's not the individual because the prevailing wage doesn't belong to you as the applicant. Your name's nowhere on it. And a lot of employers are much more hesitant to seek litigation for delays compared to employees.
Some quick announcements with regards to Vivek Saraswati. Oh, I came on J1 visa. I converted it later into H-1B. Why are you telling it's a problem? You have to stay outside the country. Vivek, I did not say that all the J1s have requirement of the 2 years home residency requirements. Some of them have the 2 years home residency requirement, not all of them. So previously, the gentleman said that his cousin had a 2 years residency requirement, though, and he applied for the waiver, and it's still been pending. So if you don't, not all J1s require waivers, some J1s requires waivers. Question that is coming up from last question is that my wife is coming from India. Do I need to have an ITN number before I file the EAD application? The answer is no. You don't need ITN number to apply for an EAD application. In fact, along with the EAD application, you can request your wife's social security number within the 765 application. There is asked the question, does she has a social security number? If not, you can apply for the social security number. She does not need an ITN number to apply for the EAD. Anything else, Emily?
I think that's about it for today. Thank you all for joining us. We'll be back as usual next week at 5 o'clock. In the meantime, if you have other questions, you can always join our daily conference call. You can go to rnlawgroup.com to get the information on when that call is. It's conducted on Zoom every day, answering all of your immigration questions. And you can also sign up for our newsletter by going to rnlawgroup.com. That way you'll get the weekly updates right to your inbox every week on Wednesday.